I'm trying to figure out what jurisdiction is this court being upheld in?
It's in Detroit, Michigan. That's located in the state of Michigan, the United States of America.
No, no. What I mean is this court in a common law jurisdiction or a criminal jurisdiction, admiralty law?
Send me the other one. The only one that did appear on the docket is the speeding ticket. Let me see what I can do about that. That's the only one you might have to dispute.
But speeding isn't a crime. It has to be an injured party, and it has to be presented.
Miss Leslie is appearing as a sovereign citizen before the court, and the court once again.
I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds.
Daniel James Williams.
Yeah, I'm here on special appearance.
Okay, do you know now special appearance means what? Because I need to have the actual person present.
You need to have the actual person present?
Yes.
Person.
So are you Daniel James Williams?
I'm not a person if you asking if I'm a person, like a legal fiction, no.
Okay. So the only person that I can have on this hearing for this person is Daniel James D'Angelo Williams. Are you that person?
Am I that person? No.
Okay. So if you know them, tell them that they're going to get a show cause. No, I'm going to call it on the record, but I need the actual person because I can't communicate with just anybody. I have to communicate with this person. Did you talk to them, Attorney Werberlin?
Yeah, so for the record, Your Honor, or
okay, let me call it then. I'll call it.
Well, yeah.
Okay. Now calling the matter of the people versus Daniel James D'Angelo Williams. This is ticket number SP 1585809. Count 1, failed to display a valid operator's license. Count 2, no insurance misdemeanor. Count 3, 26 to 30 miles over posted speed. Appearances for the record, starting with counsel, please.
And good morning, Your Honor. Ben Werbling, P64889 on behalf of Daniel James Williams. Judge, I did attempt to talk with the individual that's on screen. He indicated that he wanted to proceed in pro per or pro se, if you will. He declined my legal services at this time.
All right. All right, sir, can you state your name for the record?
For the record, the living man, Daniel Williams.
That's good enough for me. I'll take the living man. Okay. All right. This is the date and time set in this particular matter for a what's it called? Let me see where we at. Oh, it's a pretrial. In this particular matter, sir, what that means is that you're here today because it's been alleged that you have some tickets before my court. It's my understanding that Attorney Werberling tried to communicate with you and you did not want his services. Is that correct, sir?
That is correct. I do not want to contract with Mr. Waverly.
Okay. All right, sir. You know you have the absolute right to have an attorney. 2 of these tickets are misdemeanors, and that means that some constitutional rights kick into play because I can take away civil liberties such as up to 90 days in jail as well as up to a $500 fine. You understand that, sir?
That's fine.
Okay. And so at this point in time, how do you wish to proceed? The 3 options are typically you can ask for some more time so that you can come into compliance. That's called a new pretrial date. You can ask for a bench trial date. That's a trial date before myself as the trier and finder of facts. The officers who wrote this ticket will have to appear in court as well on that date. You can also ask for a jury trial. That's a trial before 6 citizens of the city of Detroit who would come down here and have to decide on this matter. Or I guess it's 4 options because you can also take a plea. I think count 3 is not in the system because they had to return the ticket. So it's really just 2 misdemeanors that should be appearing on the docket for today. Let me check and make sure. That's my ticket.
Okay, I hear what you're saying, but all this sound like you're saying like go to court, and I'll go to court if appearing in person. That sounds fine.
No, we are in court right now. So my question is, how do you want to proceed? What do you want to do? What's the next step? Do you want to have a new date so you can try and come into compliance, meaning that you want to get some of these documents like your license, some car insurance? Do you want to take a plea today? There's usually an offer that's given to folks if they want to take advantage of that and take some type of resolution in this particular matter. Or you can ask for a bench trial before myself or a
I'm
jury
just trying to
trial.
figure. I'm trying to figure
Huh?
out what jurisdiction is this court being upheld in?
It's in Detroit, Michigan. That's located in the state of Michigan, the United States of America.
No, no. What I mean is this court in a common law jurisdiction or a criminal jurisdiction, admiralty law, but
Definitely criminal. So this is a criminal matter. It's criminal misdemeanors for traffic matters.
Okay.
So that's why I told you those constitutional rights, because criminal law kicks in.
Okay, and under the criminal law, the jurisdiction of common law, it has common law and it has criminal jurisdiction, admiralty of the military tribunal review from Article 1. So I'm trying to figure out, are we under common law or the criminal jurisdiction of admiralty and military tribunal review from Article 1?
Neither. We're under criminal law in the city of Detroit, state of Michigan. That is given us power by the state of Michigan through the U.S. Constitution, as it gives powers to each state to make laws and jurisdiction and rules. And each community within that state is allowed to do so as long as it's within its powers.
Exactly, and I'm a living person, not an entity on document. I'm not
an entity in document either. I'm a living person as well. And living people get in vehicles and they drive them and they get tickets. So that's what we're here for today. How would you like to move forward, Mr. Williams? I don't have that much additional time today for it. However, I'm giving you some options so that you can be able to choose which one you want to do today. And if you don't want to participate at all, what I'll do is I'll enter a show cause. A show cause means it's a hearing where you fail to participate in my court hearing. And then if you fail to participate in the next date, then I'll issue a warrant. It's a zero bond warrant, but it'll be a warrant out there until you want to at least choose one of these avenues. It's been allegations just at this point in time that you violated some of the laws that are followed by the citizens of the city of Detroit, county of Wayne, state of Michigan, as a part of the United States of America. It's been alleged at this point in time. So all I'm trying to do is figure out how you want to proceed today. You need some more time. You want to try and get in compliance and get that license together? I don't mind. I give time for that.
Well, I have the serial QSIB number to my license and the serial QSIB contract to my insurance as well, and it's both valid. However, they're both private. They're inside of a trust. I live privately, so I don't have to show the policy enforcers my private insurance nor my ID when they pull me over from traveling privately in my automobile.
Do you have a valid license?
I have identification to prove that I'm able to operate this automobile in my estate.
If you drove on Hubbo and Eaton, that's in the city of Detroit, and that is not private property. That is very much a public road. That is a public road that is paid for by the citizens, that is paid for by the citizens like myself who pay hefty taxes to everybody to be able to allow them to ride on those roads within the city and the state of Michigan. So if I run your license, is it going to come back valid? Because if it is, we can actually dismiss that ticket. And if you have car insurance and you show it to me today, I can actually dismiss that ticket as well. Do you got some car insurance?
Yes, ma'am. I have a ongoing serial number.
Let me see it. It has to be like usually they give you a little form. I know I have to print mine out for mine.
I have paid for mine with FRNs online, so I only have the online document, and I have it in my Apple ID, so I could take a picture on this.
Can you I'm gonna send you my email address. If you could send it to my email address, that take care of two of the tickets actually. Okay, let me see. I'm gonna send you the email address.
I also have another question in settling the subject matter.
Yeah, go ahead.
After the case get dismissed, it's with prejudice or without?
If you have the documents, I'm willing to do it with prejudice today. If you have these, you see what I just sent you? Send me the insurance. We do it without prejudice, but they're not gonna refile it. You gotta have a valid license. His license is valid. Send me the other one. The only one that did appear on the docket is the speeding ticket. Let me see what I can do about that. That's the only one you might have to dispute.
But speeding isn't a crime. It has to be an injured party, and it has to be presented. And the injured party has to be having all.
You talking about civil law? That's not civil law. This is like a civil infraction imposed by the state of Michigan, and the injured party is all the citizens. Essentially, if you want to go that route, it's because we could potentially be injured by your conduct and your behavior on the roadway.
But that I hear what you're saying. You said the word potentially. Potentially, that's what you're saying. And then the state, where somebody will have to present me a statement where the party is injured. They will have to present me a statement.
Well, we can always do a hearing on that ticket. But if you send me your car insurance right now to the email address I sent it to, then I can dismiss those 2 counts because you got a valid license. And if you got valid insurance, did I send it to the right person? I put it in the chat for everyone. I'm gonna send it directly to you, Mr. Williams, okay?
Judicial conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceedings,
Mr. Watts, I'm sorry to interrupt the meeting.
No, you good. He's in here. And he's
Mr.
not
Watts, I need
connected
to. No, he's not. I'm gonna just call him on his phone.
Okay, that works.
I have another question.
Yes,
There'll
sir.
be no spot on my savings bonds, will there?
No, there won't. I'm just strictly dealing with these matters. You have a really nice, clean record. We can dismiss at least 2 of the tickets. I know you have some disputes about the last one, but just send me the other one because he has a valid license. Go ahead, Mr. Williams.
Appreciate you.
No problem. We're gonna get through this.
I'm trying to write it down because I can't really see.
Take your time. Just do it. I'm sitting right here waiting. Okay.
And that's .com or .org. I see it.
.org. I'm sorry. You see it? Attorney Werberling, we're off the record in this other matter. I'm gonna see if Mr. Wright will answer and come back to the courtroom. He did. Mr. Wright. Charles Wright. Mr. Charles Wright, press *6 on your phone or unmute yourself.
I don't know if he's even muted, Judge.
He is already unmuted. Charles Wright, I'm gonna just remove him. Maybe he'll log back on or something. Because that was your last person, wasn't it, Attorney Werberling, I think?
I believe so, Your Honor.
I'll give him 5 more minutes to sign back on. If he doesn't, then you are free if you would like to. I know we had a long week with a lot of members of our wonderful community coming in. So.
Thank you, Judge. I'll be here.
Okay. All right. Wait, let's see if he logs back on. Maybe he was having trouble hearing us. Attorney Mason?
Yes, yes, Your Honor.
All right. The only ticket, and I'm just waiting for his
SOS.
His SOS came back valid for his license, Mr.
Cool.
Williams. He has a valid license. He's in it over the insurance. It's the speeding ticket that he's disputing at this point in time. I could
What
set
is
it for, it's 26 to 31. He was doing, it was a stationary radar, 51 and a 25, alleged.
Is this your award?
This is Daniel Williams,
51 and a 35?
25, unfortunately. It looks like he was on a Hubble and Eaton. I'm sorry, I should enunciate my words, as my dad would say.
What's his record looking like, Judge?
This is it. His record is totally clean. And he does not have a CDL. This is he don't have nothing on it but his name at the top of the sheet of paper.
Okay, you know what? Okay, Mr. Williams, don't do it again, okay, please? Don't do it again. Please.
I won't. I won't.
I mean, we worry about little kids and little old people like me.
Yeah.
You know.
No,
So,
I'm part of it. Like I know y'all see the crystal. I'm real, like, you know, so it was a rough day. That's
okay.
all.
Okay, I'll give Judge, I'll leave it to the court's discretion. There we go. Whatever the judge wants to do.
Mr. Williams, when I get this little insurance, if your insurance is good, I'm gonna dismiss all 3 counts today. Look at you when you participate actively in our system.
I sent it. I just sent it to
I
you
know.
as well.
I know. I'm just waiting for it to come through. I was excited when I saw that you had a valid license. Tell your friends, please, to do what they do and get their license, because it's not that hard. And look at you. You're gonna keep a clean record today. You see that, Mr. Williams? By coming on here, I know you want to stay your ground, and I understand. As part of growing up is learning to exercise your stuff, but it's also being respectful, and you were respectful. And look what happens when you're respectful.
Yes, ma'am. I appreciate that too.
Okay. All right. Sometimes it moves a little slowly, so don't feel bad.
You know, Judge, usually I dismiss the insurances myself. I always dismiss those insurances, so you know.
Oh, okay. Yeah. I was about to say, right now he's floored me with this license after he came on here talking about the person of. So I'm excited.
Yeah, I've been doing my research since I was like 18.
Yeah, don't stop that research. You just do what you did. Act respectful. Come in here. Allow counsel to help you next time, because they're not trying to lead you down a path. And you keep that license up to date, valid. Keep your insurance up to date and valid in your vehicle, and slow down. You won't have no issues. Back on the record in the matter of People versus Daniel James D'Angelo Williams. This is ticket SP 1585809. I caught this matter already. We had to stop and get some information. Just state your name once again for the record, Mr. Williams. Please say your name.
Daniel Williams, the living man.
All right. It's my discovery that he has a valid license. We have had a nice little talk about him showing documents. He has insurance, and on the speeding, we're going to give you your break, right? But if you come back again, we'll be able to see it. So just make sure you keep everything valid, up to date, and slow down. I'm going to dismiss these tickets today, and I'll do them with prejudice in your honor, okay? All right. If there's nothing further, Mr. Williams, you're all set. Thank you, and keep that light going, okay? Don't let them kill your light.
You have a peaceful day.
You too. Thank you. All right. You can log off, sir.
Next case, State of Kansas versus Sydney Taylor Leslie, 25 CR 250. Good afternoon, Miss Leslie. Miss Leslie, you're charged by way of information on or about May 21, 2025 in Butler County, Kansas, with interference with law enforcement, a Class A non-person misdemeanor. Count 2, same date and location, no proof of insurance, a Class B non-person misdemeanor. Same date and location. Count 3, no driver's license in possession, an unclassified non-person misdemeanor. Then count 4, same date and location, failure to register vehicle, an unclassified non-person misdemeanor. And Miss Leslie, do you understand the charges pending against you?
I comprehend the alleged charges against me.
Thank you, Miss Leslie. Miss Leslie, you do have the right to counsel. If you cannot afford an
Excuse me.
attorney. Pardon me?
Excuse me, I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights, which I explicitly refuse to waive pursuant to KSA subsection 60-212 and the doctrine of special appearance recognized in Kansas jurisprudence.
Okay. You do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. And Miss Leslie, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-308. Let the record reflect that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 2004, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the four corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. The threshold matter of jurisdiction must be adjudicated prior to any other proceedings. As articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court, jurisdiction is the fundamental prerequisite to all jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
Okay, and the court finds that Miss Leslie is appearing as a sovereign citizen before the court, and the court once again.
I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds. And
Court overrules the motion for dismissal of the case. Court overrules dismissal of the
prejudice
case.
And
the court will find that Miss Leslie, that the court does find it has jurisdiction to proceed, and subsequently the court sets
I object. You called me a sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
Here, the jurisdiction challenge has already been rejected, but the same strategy continues. That feels like protecting personal authority, yet legally it risks shifting attention away from the actual charges and toward arguments the court has already decided.
Is prejudice and bias.
No prejudice or bias is asserted as to yourself. However, the court, as opposed to trying to write down docket notes to that effect, is just recognizing what you are advising the court, that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond. $3,000 cash bond has been made. Court does accept the same, and the court does schedule this matter next before Judge Webster on Monday, August 11, 2025 at 9 a.m. Monday, August 11, 2025, 9 a.m. before Judge Webster. Once again, Monday, August 11, 2025, 9 a.m. before Judge Webster. You do need to participate by Zoom process at that point. Subsequently, the court finds that Miss Leslie has not requested court-appointed counsel. Court does not appoint counsel at this point. The court does find that she has posted bond in the amount of $3,000 cash, $3,000 cash bond, and the court has scheduled her next appearance date before Judge Webster on Monday, August 11, 2025 at 9 a.m. Any other matters to come before the court, Mr. Sweeney?
No, Your Honor.
And Miss Leslie?
Your Honor, my jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas Rule of Civil Procedure. I appear specially, not generally, and have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognized in Kansas jurisprudence. Second, I challenge subject matter jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212, B1. No verified complainant from any injured party has been filed as required by KSA subsection 22-2301 in Butler County Local Rule 3.1. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudential principles adopted by Kansas courts in State ex rel. Morrison versus Celebius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my conveyance and was exercising my unalienable right to travel, placing it outside the territorial jurisdiction of traffic enforcement under KSA subsection 8-244, which by its plain language applies only to licensees who have voluntarily entered the regulatory framework. Fourth, the prosecution cannot establish the corpus delicti of the alleged offenses. As held by the Kansas Supreme Court in State v. Stern in 2015, the corpus delicti rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of officer's lawful execution of duties. Where the initial detention was unlawful, as it was here due to lack of probable cause, there can be no derivative crime or of interference. Fifth, the refusal to provide identification is not a crime in Kansas, absent specific statutory circumstances not present here today. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a person solely to obtain identification violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas courts. In one moment, please, while I gather another statement. Okay, and another thing is, and this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically, this court referred to me by the term sovereign citizen, pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The use of that term demonstrates either a prejudiced bias or a judicial predisposition toward delegating the substance of my legal posture. As the Kansas Supreme Court has held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice in open court. Wherefore, I respectfully move this honorable court to dismiss all charges with prejudice for lack of jurisdiction, issue a finding that the prosecution has failed to meet its burden of establishing jurisdiction, order the immediate return of all my property seized, including the 251 USD, confiscated and converted to a reloadable Visa card without my consent, order the expungement and permanent sealing of every associated record pursuant to KSA subsection 22-2410, award compensation for the full measure of damages sustained, including costs for my automobile window repair, bail costs, and compensation for unlawful detention and deprivation of liberty, grant such and other and further relief as this court deems just and proper. The breaking of my automobile window without warrant or probable cause of a search of my currency constitutes violations of clearly established rights for which the law provides remedies pursuant to the maxim ubi jus ibi ridium, where there is a right, there is a remedy. I reserve all rights without prejudice, waive none, and maintain my special appearance for the sole purpose of challenging jurisdiction and preserving my alienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And thank you for hearing me. I do appreciate you, Your Honor, and thank you for your time.
And once again, matter is set before Judge Webster on Monday, August 11, 2025, 9 a.m. by Zoom. There being nothing further to come before the court is in recess, and have a good day, Miss Leslie.
Thank you, Your Honor.
And Mr. Sweeney, that's the last case I show on the first appearance docket.
Thank you, Your Honor.
Have a good day.
You too.
The two hearings show an important difference in how a courtroom dispute can develop. In the Kansas case, the defendant made jurisdiction the central issue and continued building that argument after the court had already ruled that it had jurisdiction. The court then set another appearance and recorded a $3,000 cash bond. In the Michigan case, the defendant also began with familiar sovereign citizen ideas: special appearance, living man, private status, and questions about jurisdiction. But the judge kept bringing the discussion back to something concrete: valid licensing and insurance. When those documents were produced, the court had a direct path toward resolving the charges. The judge ultimately dismissed all three counts with prejudice. That contrast matters, because courtroom strategy is not only about what someone believes, it is about whether the argument moves the case toward a legally recognized resolution. A theory can feel internally consistent while still failing to answer the question the court is actually deciding. The Kansas hearing shows the cost of continuing to fight the court's authority after the court has rejected that position. The Michigan hearing shows what happens when the discussion eventually moves toward documents the court can verify and use to resolve the charges. Neither hearing turns on who sounds more confident. The practical difference is whether the defendant's chosen strategy creates a path toward resolution or keeps the case focused on a dispute the court has already addressed. That is the larger lesson across both proceedings. In court, the strongest position is usually the one that produces a legally usable answer.